Good morning and also good evening to our panelists and also to our online participants. Welcome you all to today's webinar on the US-China rival approaches to data link decoupling. My name is Nong HONG. I am the Executive Director of a Washington-based Institute for China-American Studies. So our research focuses on many of the key issues affecting or concerning US-China relations that are in need of greater mutual understanding, including data governance that we'll be discussing today. Today's webinar is a part of a series event of ICAS Trade and Technology Program, which was launched last summer. And the goal of this program is to analyze the evolving dynamic of US-China trade and technological affairs, and also providing timely products on issues involving the developments, and also to expand public dialogue surrounding this critical topic as we are going to do today. Data is the indispensable resource that will fuel artificial intelligence, economic strength, and national power. So the competition for global influence today will require protecting the data to achieve commercial, technological, and military advantages. So as you will see from what is online in our program, a series of questions around this topic remains for further discussion. For example, what are the drivers behind the US-China divergent approaches to data sovereignty, and what are the key takeaways from the existing rules and regulations, and who are the key players involved? And also a deeper question worth discussing is, when China and the United States cease to influence Indo-Pacific cross-border data flow, rules, and stands, what are the implications? So today's panel will be moderated by Dr. Yawei LIU. Dr. Liu is the Senior Advisor on China Issues at Carter Center. And Dr. Liu is also a Senior Member of ICAS Board, Advisor Board of ICAS. We have 4 distinguished speakers for today's panel discussion. You're going to read the full bios on our website, and my colleague will just share the link in the chat box. Let me just quickly introduce our 4 speakers. Mr. Paul TRIOLO, he's the Senior Advisor, Vice President for China and Technology Policy Lead at Dentons Global Advisors-Albright Stonebridge Group. Prior to joining SG, Paul led Yawei Group's geotechnological group. Dr. Denis SIMON, he's a senior advisor to the president for China Affairs at Duke University, and he's also professor of Chinese business and technology at Duke School of Business. Dr. SIMON is also a senior advisor to ICAS Trade and Technology Program. Ms. Kendra SCHAEFER, she's the head of tech policy research at Trivium, China, and a non-resident fellow at the National Bureau of Asian Research. And certainly my colleague, Sourabh GUPTA, he's a senior fellow at ICAS, and he's also leading ICAS Trade and Technology Program. So without further ado, let me give the floor to Dr. Liu.
Thanks, Dr. Hong. So good morning to everyone that are attending this webinar in the US, and good evening, Kendra and others, to those that are in China. It's getting late. And as Dr. Hong mentioned, this is a TNT, Tech and Trade series that China, the Institute of China-American Studies got started back in July. So for those who are interested, you can go to the website and find out more about the 3 previous webinars. So this is the 4th one with a focus on data. Growing up in China, looking back, I felt that it took 30 years before the Chinese leaders completed that debate and they declared to the people science is a productive force. It didn't take much time for leaders in China and the US to realize that data is actually a very important source of productive force. But the issue is, how long does it take for the 2 sides, for the East and the West to agree, to come up with a global standard to collect, manage, and use data? So that is going to be the focus. And looking at the title of today's webinar, it's a little intriguing because one thing you talk about collision, and the other you talk about decoupling. If it's decoupled, then I guess a collision might have been avoided, but I don't know. So we'll have to refer to our specialists, the experts to talk about this. So our first speaker is Sourabh GUPTA, our own from Institute of China-American Studies. So Sourabh, the mic is yours.
Thank you, Yawei. Good morning to all, and good morning to my panelists. The reason I thought I would go first and speak today is because my role here is purely to set the table for the other panelists to speak. They are much wiser on this topic, and I think they have a lot more to share. So I thought out here what I would do is just give a very straightforward table setting of basic Chinese and US approaches to data protection, data management. I have a short presentation out here. There's quite a lot of material in the presentation. I'd say don't be detained by the material. The material can be made available if necessary later. Just the fundamental points that I'm trying to get across. Let me get that across to you all. I'm going to start sharing this thing. Again, as I said, just a table setter. First, let me get to the US approach to data protection and data flows. We're not just talking about data sovereignty. I mean, for the United States, I mean, the word sovereignty itself is something which I think a lot of people, policymakers, would be opposed to, because data is supposed to flow. It's not supposed to be something held within borders per se. And therefore, if there's one real takeaway with regard to the US approach, I'd say that it's more or less a kind of a laissez-faire approach to data, to cross-border flows. It's, of course, US has these big platform companies and all who have global reach, and the US government sees that it's important that their reach expands because they have much to offer in terms of their products. And therefore, as you see, there's a very strong commercial bent at the US end in terms of not protecting data, in fact, allowing data to flow. And there are just some very narrow exceptions which are essentially laid out in terms of where data should not flow, or how, if data does flow abroad, how it can be managed or controlled. I'm just talking now about the exceptions. Please bear in mind that this is in the context of US government and US policy approach generally being to have flows rather than restrictions on data. What are those few restrictions on data? I would suggest one is that data should not be shared with adversaries. Depends. I mean, adversaries need to be listed out. It's in other US regulations. There are adversaries listed out. I don't think in any of the executive orders with regard to data that we have a listing of who an adversary is. But I mean, understand. I mean that China is deemed to be the adversary, one of the key adversaries. The first one which you see on the screen out there on the left-hand side, it was President Biden's executive order, which he passed in June, which overrode President Trump's executive order. President Trump's executive order was occasioned by the issue of TikTok, TikTok and WeChat, and we need to either kick them out or we need to have them bought over by Oracle and et cetera, and none of that got consummated at the end by the time Trump left office. And what Mr. Biden did was he basically tore down the Trump executive order, and he had his own executive order, placed his own executive order, and rulemaking is proceeding in that regard. And what I just have on screen out there are some of the proposed risk factors to be considered when, as it says, a foreign connected software application, WeChat, TikTok, may pose a risk to US security. And those are the lists, a list of the risk bases. Now, the reason I have got that, then what is it, the fourth one listed out in red out there, is just to highlight it, because, you know, we're talking TikTok, we're talking out here, and the thinking is, it's still preliminary at this stage, but there might potentially be restraints on TikTok because of what you see out there, lack of thorough and reliable third-party auditing of connected software applications, i.e. TikTok, and that may involve perhaps when the regulation is fixed, that folks like TikTok might need to have their source code examined, or monitoring of their logs, or that their user data needs to be monitored by a third party. And this kind of goes a little bit against the grain about how US has dealt with data flows, because, as I said, it's been a laissez-faire approach, and this can set a tricky precedent. And that's why there are US companies not terribly happy, even though it doesn't have to do anything with US companies, that it could set not a very great precedent in terms of US intervention with regard to US putting its thumb on issues related to data flows in a way which might not be very beneficial from a long-term perspective. Again, let's go to the right-hand side of the screen. It's with regard to, you know, the upgrade of CFIUS in 2018, in August 2018. And the only reason for listing it out there is that it listed out what are categories of sensitive personal data. At this point of time, US really doesn't distinguish itself between personal and non-personal data in terms of data flows. But someday down the line, if that distinction does happen, because there is movement, there is in Congress sentiment in trying to have better privacy rules, these could be basically elements of how they might define sensitive personal data. Anyway, we're talking exceptions here. One was foreign adversary related. A second one is, and this is not really an exception per se, as much as it just goes to show, I know there's a lot of material on the screen, don't be detained by that. The main point I'm trying to get is that in 2018, the US passed the Cloud Act, which essentially subjects any communication service provider that is subject to US jurisdiction. With regard to a valid US legal process, it needs to turn over the data regardless of where the data is stored. And this was occasioned by the Microsoft case, wherein it stored its data in Ireland, and that data was required for law enforcement purposes. And so essentially, from a law enforcement perspective, if that data sits on an American server or is subject to or belongs to a company that is subject to US jurisdiction, that can be recalled back for law enforcement purposes. And so this is not a restriction on data flows per se, but it's exercise of juridical competence over that data, regardless of where it is. It's a kind of an extraterritorial reach, but that's not unique because the EU does that. And as we'll see, even China is moving in that, is going to do that as part of its regulations. The final exception I was talking about out here is with regard to, this is in terms of digital trade agreements. We have the US-Japan agreement where it says that financial data can flow abroad. This is part of the digital trade agreement, but if so long as that data can be US financial supervisors can have immediate access to that data. Now, this was an issue in the TPP negotiations where this was not actually allowed. And TPP, of course, then the US stepped out of TPP, it became CPTPP, et cetera, et cetera. But that was 2016. By 2019, the US had changed its position, saying that, yes, financial data also can go abroad, go overseas, as long as that data as long as US regulators can have immediate financial access for supervisory purposes. Now, last thing I'd say about regarding the US side is that this is not set in stone. As I talked, the heavy commercial bank, laissez-faire approach, but we know that there is a movement, there's growing sentiment from a privacy perspective, from an antitrust perspective, to kind of rein in big tech. And that's going to have implications even in the US's digital trade agreements. whether it is with regard to source code related stuff, as we saw with regard to TikTok, there might be movement in that third-party monitoring. With regard to internet intermediary liability issues, Section 230, and should that be in trade agreements or should that not be in trade agreements? And issues like encryption, where FBI and all have been very much against it, and that at this point of time, trade agreements are very. The point is that this could become a point of contention too, but this is generally the U.S. approach: laissez-faire, commercial bent, and with very narrow exceptions. Let me get to China out here. China's approach is very different. It's a very concerted state-managed process. The main goals with regard to data flow, its data flow approach is primarily from a fintech perspective, from a privacy perspective, and growing, as we've seen of late, from an antitrust perspective, so that they can create better data markets out there. And the approach has been a very comprehensive one. It's comprehensive because, it was initially a focus on security. There was a national security law in 2015, national cyber security law 2016, national intelligence law 2017. The focus shifted there, and focus shifted thereafter, I'd say, towards perhaps data protection. You had during this last year, data security law, a personal information protection law. And in the process of putting out all these laws, I think China is also reviewing how China can do cross-border data flow, and in a very concerted, comprehensive, managed approach, but also with a liberal approach. Liberal in terms of, and that's why you'll see on the left-hand screen, there's a system, a system of hierarchical protection and flow of data, where data is broken down by general data, that's non-personal data. Then there's personal data and important data. And then there's core data, which is just not being defined at all. But there is this issue of personal data and important data, which is subject to exit assessment, but can flow overseas. Regulations are still being written at this point of time, so it's still very much a work in motion, but the bent is to allow the data to go overseas, but where the perimeter resides with regard to security assessment and how that is conducted is something which is very much ongoing at this point of time. And we'll see, as I'll show later, there is extraterritorial reach also involved out here. Some quick provisions. One doesn't need to go into great detail out here, but there are particular triggers, as I said, for data security assessment, for the data to go overseas, with the bent being that let's have the data flow overseas, but let's also create these thresholds. And you see the thresholds kind of listed out there in terms of assessment, if it's important data, if it's seeking an overseas listing, if it's a provider, if the platform operator is provider of a cloud computing service, or is a critical infrastructure operator, or a large scale internet platform operator, or is using new technologies such as AI, virtual reality, deep learning, there is higher security assessment involved out here. And those also, as you see, with regard to cross-border data transfer. In a draft regulation, which was put out in November, for the first time, I saw a greater depth and detail of what constitutes important data was provided. This is just what I have out there. There's a little more on the next page. What I have out here is just a subset. It's not all of what falls under the important data category, but it's useful that they're thinking through in what is important data, what requires security assessment, and thereafter where it can flow and the rules under which it can flow, and also the rules under which it can be called back. I mean, there is going to be extraterritorial application. This is the way I think the EU is also at, where it is basically you enforce jurisdiction based on the source of the data rather than where the data is located for storage or processing. And as we've seen with the Cloud Act also, I mean, the US has the means to recall that data back. As you're noticing out there on this slide, they've newly come out with this concept of core data, which is completely not defined. It's very broad, and we'll have to wait till we get some definition of it. And finally, on that last page, as you see, these are some of what the US says are offending provisions in Chinese laws related to data, in the sense that it kind of coerces or forces companies and Chinese citizens to work with the state in terms of providing that data when it is sought, with the insinuation that, you know, they're going to be heavy-handed in calling that data in, which might or might not be the case. But anyway, I'm going to stop out here. I think I've taken up more than the time I should have taken. The main point, again, I wanted to get at out here was US was laissez-faire, commercial bent, narrow exceptions with a foreign adversary exception. The Chinese don't have any foreign adversary exception per se, but it's a concerted, comprehensive approach, and it is a structured approach with a hierarchical differentiation of data in terms of allowing flows. And I would submit that the purpose of China is moving away. Is the initial focus was on data protection. The focus now is more on flows, but also without forgetting about that protection. And that protection is not just about data as software, but also the hardware, you know, server infrastructure, et cetera, which also allows that data to flow. And so at this point, let me leave the presentation, let me leave it out here, and let me leave it to my panelists to take it here from there on. Thank you.
Thanks, Sourabh. As an outsider, you know, the more I listen to you, the more I think this is, both sides are busy erecting the equivalent of the Berlin Wall, you know, separating their data. Our next speaker is Paul TRIOLO, who is the Senior Vice President for China and Technology Policy Lead, Dentons Global Advisors and Albright Stonebridge Group. Now, Paul, before you go into the data issue, can you just tell us a bit more about where you're working now? I know you used to be at the Eurasia Group. Now, is this a combined Denton and Stonebridge group?
Yes, there's a partnership, Yawei, that we have with Dentons Global Advisors and Dentons law firm. So we have, it gives us a big global presence, and a lot of leverage to work on a lot of different projects. So including data issues. So let me, thanks, and great comments, Sourabh. Let me just step back a moment here. I think, you know, there's a lot of issues around data here. I think you gave a good summary there. I think it's important to note that what we're really talking about here is how do we retain interoperability or develop new ways to interoperate between countries and regions with very different legal systems and drivers for data privacy and protection, and how this sort of ends up spilling out into areas like cross-border data flows, data localization, and importantly, government access to data. And this is all, of course, happening at a time when the amount of data that is traversing networks has skyrocketed, whether it's 5G or AI. And then we also have these sort of geopolitical overlays, US-China relations, you know, where again, there's a lot of pressure, particularly around things like government access to data. And some of the existing structures that were developed for this interoperability are under a lot of stress. We've just done a lot of work, for example, for clients on Privacy Shield. So even as we speak, Privacy Shield is being renegotiated after the original Privacy Shield was struck down in 2020. And 2 years later, we still don't have an adequacy agreement essentially between the US and the EU to transfer data across between, you know, two democratic, you could argue, you know, jurisdictions with similar legal systems and approaches. So that just shows how difficult the issue is when you start throwing in things like government access to data and like some of the other issues that are adjacent, like platform regulation and other issues like cybersecurity. So let me just I wanted to touch base on sort of elaborate a little bit on where the U.S. is, and then I'd like Kendra is going to do the China piece. I think Sourabh touched on some issues, but I think she has a great handle on that. In terms of the points that Sourabh made, I think it is important to note that, you know, in China, there's been this really robust debate about the data issues and how to deal with data. And it's really a 5-year process, you could argue, since the 2016 release of the cybersecurity law. And it's interesting because, you know, in terms of looking at how governments and regions are looking at these issues, I would say the EU, of course, is is always out in front on regulation and has lots of regulation, and we can talk about what the EU is doing. So the EU is sort of a standard out there in terms of the general data protection regulation and a whole host of other regulations that are in the works that relate to data. But China, to its credit, has also had a vigorous internal debate on how to deal with data, how to classify data, as Sourabh mentioned, into these different categories, and then what to do about both protecting data and then allowing cross-border data flows in ways that don't impact businesses. Because again, this is sort of my client. I'm dealing with clients every day who are dealing with complicated issues. They want to be able to send data, aggregate data, for example, from their global platforms, financial services companies, so they can detect fraud, right? I mean, there's lots of very basic issues that require cross-border data to flow, so that global multinational companies can do what they need to do, and their operations are able to continue. So I think it's important to note that we do have these three really big different approaches to this. The EU, of course, is starting from this concept that data privacy is an inherent good, it's a right. And so we have this whole edifice that's been built up since the GDPR was implemented in 2018. And it's based on fines, large fines for breaches of GDPR rules. Now, it's proving to be really difficult to enforce that. And there haven't been that many cases brought against companies for violations there. So that even something as comprehensive as GDPR has proven difficult to implement. And so there's lots of other efforts right now in Brussels, like the Digital Services Act, the Digital Markets Act, and the new Data Act, and the EU AI Act, all of which have important data pieces to them. And so the Brussels effect is out there. China now then in its approach, it has looked at the GDPR experience, but it doesn't like the GDPR experience, which is too much regulation, and it doesn't like the US approach, which, as Sourabh noted, has been somewhat laissez-faire, but it's been basically to punish companies after the fact, for example, if there are data breaches of personal and other data. So China is trying to sort of chart its own middle ground between the EU approach and the US approach. And this is in keeping with Chinese preferences for things like categorizing data. So they did that. We saw this with the multi-level protection scheme, for example, where they divided equipment into which networks could be used and which were critical from levels 1 to 5. So this is a very Chinese approach. In the US, though, we have a very messy system. We have no single US federal law that comprehensively regulates the collection and use of consumers' personal data. Congress has enacted a number of laws designed to provide statutory protection of individuals' personal information, but it uses a sectoral approach, again, which is very different from the EU and China, that relies on a mix of legislation, regulation, and self-regulation. So, for example, the FTC can bring enforcement actions against companies who mislead consumers about their privacy practices, but the FTC does not have a mandate to enforce broad online privacy protections. So the US has this very, very messy system, which, again, yes, arguably it's good for innovation because it doesn't impose these major sort of large frameworks where all companies have to comply, and smaller companies end up getting disadvantaged, for example, if they have to put in place a data protection organization within the company. So there's some advantages to the US system. The question is, is that going to be useful going forward? And many U.S. officials do maintain that the U.S. approach to data is more nimble than what they view as the EU sort of one size fits all. So there is a sense in the U.S. in Congress that they don't really like the EU approach. They don't want to sort of adopt the EU approach. We did a long note for clients last year that sort of looked at the range of where the U.S. could go on some of this, from GDPR light to something more like GDPR. But obviously there's a lot of resistance to that type of approach to data regulation. And then on top of that, of course, you do have, as Sourabh mentioned, this concern about the big companies like Facebook and Amazon and Google and their use of data and their collection of data. So this year, for example, I think one of the big things will be further movement on antitrust and around a lot of issues related to the large tech companies. Now, of course, they're using the China card here, which is, hey, if you regulate us too much and you control the way we use data for our business models, it's going to favor Chinese companies because they're not going to be under the same regulation. Now that's obviously changed recently with a lot of the regulation of Chinese tech platforms, which Kendra can address here. So I think it's important to remember that what's happened in the absence of U.S. Sort of comprehensive data regulation is you've had a lot of sort of one-off things happening over the last few years. And so you did have in the Trump era, as Sourabh mentioned, you had CFIUS, for example, getting into the sort of data, the U.S. personal data issue and rolling back deals that had been approved, like for patients like me and Grindr, where there was the case of Chinese companies that might have access to U.S. healthcare data. And CFIUS is going to continue to look at and potentially roll back any deals that involve, for example, potential Chinese government access to data. And then you also had, of course, the Trump era executive orders to ban Chinese social media apps. Now that proved to be a really, really difficult process, and it was challenged in court by WeChat users and TikTok users. TikTok has 100 million subscribers in the US, including a lot of influencers who are making a lot of money. And so the Biden team had to sort of, had to climb back down off of that and rescind those executive orders last summer. And they're in the process now of trying to figure out how do we regulate these connected apps that Sourabh mentioned here. And that's a complicated issue because the US legal system isn't really equipped to deal with that. And there are things under some of the authorities used for the original ban, for example, that make it so you can't restrict communication. And that was the legal basis, for example, for the court pushback on WeChat. So the TikTok issue is going to come back around, but the TikTok issue also, of course, involved the CFIUS case, where CFIUS was trying to basically roll back the TikTok's acquisition of Musical LY, which is a U.S. company. But that has also run into a lot of issues. So, despite declaring a national emergency about personal data and potential Chinese government access in 2020. 2 years later, we still, have more TikTok users in the U.S. and there's no clear legal path to figuring out what to do about that. Now, in the case Sourabh mentioned, that one of the mitigation, as part of the mitigation strategy under CFIUS, there was a really novel attempt to have a U.S. company like Oracle host the data of Chinese apps in the U.S., for example, and have them review the source code of the AI algorithm. And a lot of companies we talked to at the time thought that might be a model for how Chinese connected apps could operate in the U.S. But it proved to be a really difficult issue, and it wasn't clear the Chinese government would have approved, for example, Oracle reviewing the TikTok source code. So that's an issue that's going to come back around here. And then we also, on top of that, have the Commerce Department issuing an ICTS supply chain rule stemming from another Trump era executive order. And that includes a lot of data related provisions around connected apps. And I think that's going to be probably where the focus is. In November 2021, the Commerce issued a rule that would essentially add this issue of reviewing transactions involving connected apps to this ICTS supply chain rule. Now, the problem there is there's still no CFIUS-like apparatus in the U.S. government, at Commerce Department, to review transactions and to make decisions. You have to actually have people, who are empowered to do that. And so far, there's no office at Commerce that's prepared to do that. So that's nothing's going to happen on that, we think, anytime soon. And then, of course, you had in the Trump era the concern about Huawei and the potential for companies like Chinese companies to enable Chinese government access to data going over the equipment. And so that became a huge issue around things like the Clean Network Initiative, and basically saying that this idea of adversary equipment should not be allowed to carry, the lifeblood of democracy. You heard this kind of thing. So that's another complicating factor. And then also the U.S. government ratcheted up scrutiny of companies like global commercial drone leader DJI, because there was concern about whether its data could be that was collected on U.S. infrastructure, for example, could get back to Beijing. So as Sourabh mentioned, the U.S. government commentators over the last 2 years have made a lot of comments on whether Chinese laws like the cybersecurity law, the national security law, the intelligence law, whether these mandate Chinese companies turn over data to the Chinese government. And we can have another discussion of that, but that's not what those laws say. Those laws are very general, and they say that the companies should cooperate, but they don't say the companies have to turn over data to the government. So the interpretation of that, I think, has complicated the whole discussion in the US around Chinese government access to data. And we can come back to that issue. But then the other factors, and I'll skip ahead here, are things like this year that are really going to be the key focus of US data related discussions. One is is in the trade arena. So whether the US, for example, would rejoin CPTPP with its very high bar for things like data localization and ensuring cross-border data flows. Now, that's not going to happen in this administration because there's just too much opposition to a trade deal. And so instead of a trade deal, the US is looking at something like the Indo-Pacific Economic Framework, which again, we can talk more about. But the IPEF has a big digital economy portion to it, and that specifically mentions, or is likely to mention, cross-border data flows and data localization. And the CSIS did a really good paper on this, Matt Goodman and Bill Reinsch, that lays out, that tries to flesh out what this would mean. Now, the problem is this is not going to be a binding agreement like a trade deal. And so the question is, are Asian countries going to be eager to sign up to some new sort of arrangement that is not a trade deal? At the same time, of course, China has signed up to join CPTPP. And this is going to be a huge issue this year as that application moves forward. And China, of course, I've been in some track 2 discussions with Chinese officials, and we've been talking about the data issue, and they claim, for example, and I'd love to hear Kendra's comments on this, that the Chinese data regime is flexible enough to align with CPP Chapter 14, provisions on cross-border data flows and data localization. So that's going to be a huge issue this year. There's lots of other issues with China's accession to CPTPP, but basically most countries in Asia would love to see both the U.S. and China in CPTPP, because that is an existing framework. It's well thought out. It's took a long time to put together. And I don't think there's going to be an appetite, for example, to put a lot of effort into something like the Indo-Pacific Economic Framework, even though that's where the U.S. is going to put most of its sort of trade and digital trade effort this year. So in sum, because I know we need to leave a lot of time here, I think this year the U.S. approach to data is going to remain fragmented without overarching legislation on data privacy. We're not going to see that. In addition, this lack of overarching law is complicating U.S. relations with, for example, the EU over issues such as Privacy Shield, which will probably be resolved in the next month and will be a major win for both sides here. But it's also a difficulty that lack of a data privacy law is also hampering issues like how to deal with connected apps like TikTok and WeChat. There's no sort of standard for the US that could be applied to all companies, not just Chinese companies, for example. And so then finally, the US position on digital trade agreements and where those stand is going to be a big issue this year. And updating policies, for example, laid out in CPTPP is going to be important because the world continues to change. So it's, for example, in the IPEF document that CSIS did, they highlighted all the other digital agreements in Asia, for example, the Japanese agreement, Singapore, where those countries are starting to do a lot of bilateral agreements that are building on some of the digital arrangements in CPTPP. So the U.S. is way behind the curve. The bottom line is the U.S. is way behind the curve in terms of having a really coherent strategy on data to be able to engage both with the EU and with Asian partners and with China, one could argue. And at the same time, China then is really driving forward and doing a lot in the data space that is very thoughtful and innovative, I would argue. And so I'd love to hear what Kendra has to say about that. But I think we're at a really critical juncture here where China appears to be more thoughtful on these issues than the US. And the Biden administration is really struggling, I think, on the data issue going forward. And I'll stop there and leave it for questions later.
Thanks, Paul, for that story of how fragmented and incoherent and messy data system that US has. So we're eager to hear from Kendra SCHAEFER on the China narrative. Does China do a better job? So Kendra, the floor is yours.
Hi. Well, it's great to be here. Thanks for the introduction. I don't know about you guys, but it's kind of hard to talk about anything that isn't the meltdown in Ukraine right now. So thanks for coming, listening to a data talk. My name is Kendra SCHAEFER. I'm based in Beijing. I've been here about 20 years. And I'm the head of tech policy research at Trivium China. That basically means that I just dig around in government documents all day long. And specifically, I'm looking at documents related to tech and data. So we look at AI, we look at algorithms, and we've been and data, of course, and we've been very busy, right? Because as you all know, data's been one of the fastest moving policy areas in China. Very recently, I would say in the last 2 years, we've seen China make some extremely forward-thinking moves on data. They had been kind of following in the EU's footsteps very cautiously for many years on data policy. Suddenly they've kind of leapt ahead. But what I really want to do today is specifically address something. Instead of trying to cover every single thing that China's doing on data, because there's so much, I want to zoom out. I want to look at one issue in particular. It's an issue that Paul mentioned, that all the other speakers have mentioned, which is the issue of data classification in China. And it's a fascinating topic. And it's a topic that I don't think people understand how important it is and why. And so I'm going to talk about that today. So as you probably are all very familiar with, right? Last year, China kind of finalized its data governance regime, releasing the data security law and the personal information protection law, laying out some basic buckets for high risk and medium risk data, right? We've got these kind of legal terms now that identify data that's high risk and identify data that's medium risk. Those terms are, important data, national core data, sensitive personal information, and personal information. And often in the US discourse about this, right, when we talk about data, restrictions in China, the word that comes up most often is like control, right? China wants to control data. And clearly that's true, but is really the whole, like, what's the bigger picture there, right? China wants to control data because control is power, and power is money, and money is good, or that doesn't really follow. Or is there a bigger strategy? And based on what we're seeing, China's big picture strategy, the 10-year, 20-year, 30-year plan, the vision for what the country wants to do with data is really coming into focus. So that's what I'm going to kind of talk about today. I'm going to pull out and look at the kind of highest level rationale. And ultimately, that rationale centers on the importance of developing the digital economy and China's data market. What we're basically hearing China's top economists say is that growing the digital economy, right, and making sure China's digital economy is vibrant is vitally important, not just because China wants to foster innovation or be a global leader in e-commerce or be a global leader in trade, all those things are true, but because the digital economy is critical to the growth of the economy overall. According to a white paper that we read recently by tech think tank CAICT, right? China's growth, we're all sick of hearing this, China's growth has kind of slowed down to a 30-year low, but the digital economy is growing by leaps and bounds. This year, I think it was in 2004, digital economy represented 1.2% of China's GDP. Last year, it was 38%. It's projected to be 55% by 2025. So basically, the rapid growth of the digital economy, the way that we've seen policymakers frame that, is helping China respond to this kind of downward pressure on the economy overall, right? And so, if the digital economy is one of the key engines maintaining China's forward momentum, then as we know, right, data is the gas that powers that engine. It's the input to the growth of the digital economy. Just as, right, land and labor were kind of these critical inputs to the agricultural economies of yesteryear, right? You're in an agricultural economy, you want to generate value, you need a plot of land and you need a guy to farm it. Data is the critical input to the digital economies of today, right? And that's not just an analogy. Top party documents say that explicitly in exactly those terms, right? One document in particular, in April 2020, China's top policymaking body, right, the State Council, released a landmark document formally naming data, and some of you may have read this document, formally naming data as one of the most critical resources necessary for the creation of economic value, right? The other resources being land, labor, capital, and technology, right? These resources are called factors of production, right? Land, labor, capital, and technology. So as of April 2020, this is remarkable, in party approved economics, there are 5 things that the state has to manage well in order to generate value and economic growth: land, labor, capital, technology, and now data, right? But paraphrasing that very important document, as Chinese policymakers see it, data is kind of the odd man out on that list. And that's for a very simple reason. It's because most economies, right, including China's, have been buying and selling and trading land, labor, capital, and technology for decades, right, if not centuries. And that means the rules and regulations and laws, all the stuff you need to have a healthy market, already exist for those other resources, right? Those land markets, the labor market, those are reasonably well regulated, reasonably predictable, reasonably orderly. You want to buy some land, you probably know, how to find out whether you're allowed to sell the land you have, who you're allowed to sell it to, right? But we really only recently began buying and selling and trading data, right? At least at this scale. And the market is extremely immature, not just in China, but globally. This is an international problem. And every country is kind of struggling with these dozens of unanswered foundational legal, procedural, and like financial questions that are kind of standing in the way of an orderly, predictable data market, right? Many of those issues are so foundational and so basic that the man on the street tends to assume we've already sorted them out, right? Things like, how can you own data? How can you transfer ownership of data? How much should data be worth financially, right? We don't have pricing valuations. We don't have quality control schemes that are standard, right? How do you tell what good quality data is? So all of these little market conundrums, these foundational market conundrums haven't been solved. But the most critical of those issues, right? The most foundational, the one that's giving Beijing the biggest headache when they try to figure out how to build a data market, is that we don't know which data is safe to trade, right? China's projected to generate a quarter of the world's data by 2025. They will make more bytes of data than there are stars in the observable universe, right? And, as you know, there's so many kinds of data: financial and credit data, GPS data, personal data, anonymized user data, meteorological data, population data, commodities data, right? It goes on and on and on. And obviously, some of those, all of those types of data have the potential to generate enormous economic value. But the question is, which of those data types present a risk to national security or personal privacy that outweighs the economic rewards, right? Which types can we safely generate economic value from? Which can we let companies buy and sell freely, right? So we've already answered that question for the other four resources, right? Land, labor, capital, and technology. Land is a great example, right? It took us a couple of 100 years, but in the US, we've zoned every square inch of land into buckets, right? This land is agricultural. This is residential. This is commercial. This is, protected forest land. And since we have those buckets, the state can come in and make rules about what you can do with different kinds of land. Agricultural land has to be 20 kilometers away from, city center. You can't develop an apartment complex on protected wilderness areas, right? You can't build residential property over there. You can build it over there. And this is exactly what China's trying to do with data, right? This is the big picture economic thinking underpinning the data classification schemes that we see in the data security law, the personal information protection law, right? And so essentially, one of the most interesting things that these laws do is define some basic legal zoning categories for data, right? High risk and medium risk data. High risk data is like protected wilderness. You probably can't develop on it. You probably can't export it, right? You're probably going to have to store it locally. The risks of letting people do whatever they want outweigh the rewards. But if you want companies to buy and sell and trade data fluidly, right, you have to tell them which is which. Now, in Europe and the US specifically, we've got these broad general ideas of personal information or personal health data in HIPAA, for example, but we haven't taken it any farther than that, right? China is doing the opposite. These laws, the data security law and the personal information protection law, are just the very beginning. Now what we're seeing is Chinese state agencies have been ordered essentially under the data security law to look at every single kind of data, all the data that is generated in their sector, and then classify all of that data by its level of risk. So for example, you've got, the state grids classifying electrical data. The telecom regulators are classifying telecommunications data. The environmental regulators are classifying, environmental data. And the idea, this is a wildly ambitious project. I mean, this is an incredibly ambitious project. It hasn't been done by any country anywhere in the world, right? Nobody has tried this. And it could be, the end vision, the final goal, right? What Beijing's trying to accomplish is they see a world in 20, 30 years where any government or body or any business could look at the data that they have and say, okay, I've got this kind of data. I know exactly what I can do with it. I know how I can sell it. I know who I can sell it to. I know where I can send it. I know where I can't send it, right? Real granular data classifications. But this could go horribly wrong. This could go horribly, horribly wrong, right? They could over-classify data as restricted. And what that would mean, right, is that Chinese companies would have a very difficult time exporting their data. Data trade would become overcomplicated. Companies couldn't, when they try to take those data regulations and match them up with data regulations in Europe or in the States, if the States ever gets any, then you're going to see a real mismatch in those schemes that'll just hamper trade. But the vision there, right, is incredible. And we really don't hear a lot of people talking about this kind of super granular, trade identification anywhere else outside of China. So if there are any lawyers in this room, if there's anyone who's read the data security law, I encourage you to go back and read it again, because with that in mind, right, that China's taking an economic approach to data protection. Because what you will find is that half of the articles in the data security law talk about companies' obligations to protect data. The other half of the articles talk about the state's obligation to develop a data economy, right? They say that the government has to help industry safely trade data, right? 20 articles in there talk about that. So I'll stop there. It's a very different approach to what's going on elsewhere. I'll leave you with that big idea, and I'll leave the floor open for questions.
Thanks, Kendra, for that very detailed description of how China is classifying data, and it is a monumental task. Now, Dennis, you're the cleanup hitter, so there you go.
Great. Well, thank you. And thank you to ICAS for organizing this. It was a great foresight to pick this topic, given what our three previous speakers have said. And in many ways, there's not much left on the table for me to talk about. But let me try to throw out a couple of ideas. And I'm happy to say that Kendra and I seem to be reading the same documents about this, because I also come to some of these same conclusions, but maybe with a little bit more of a twist to them. The one thing that seems to be sure is that the entire landscape of global governance and management of data has already become more challenging than we expected. And we have now multiple regulatory regimes, multiple legal structures, and we have tighter controls afoot. And this is going to give a lot of people a big headache, whether you're a corporate planner or a government, or even from my experience recently as a university, make the road a little bit more bumpy and add elements of risk management now into the equation that simply didn't seem to be there before. And as Paul has said, I think it is very important to understand that this really is about interoperability, and that is that the smooth movement of data without high impedance is something that everyone seemed to have wanted. But the degree to which control factors now have seriously entered into the picture is not an unimportant part of the entire equation. So I'm going to talk mostly from the perspective of China, but try to broaden it out. I think, as Kendra suggested, the China that we see today is very different than the China that existed just a few years ago. And I think it is this onset of the digital economy that really has changed the picture. And in China, it's become a reality. In fact, if you look at what happened as a result of the COVID pandemic in China, the acceleration of the digital economy owes a lot to the fact that it grew during COVID in a way that probably was even faster than most expected, and gave a lot of impetus to the use of internet-based life for a lot of people. Now, we know that this is about e-commerce and about fintech in some parts, but I think it's even more important than that. There are close to 1 billion Chinese internet users today in the world. And I think that as China looks out into the future about the nature of its economy, and particularly this notion that the digital economy is now going to be the central driver of economic growth into the future, I think Chinese leaders have gradually but steadily started to rethink the way they look at their own economy, and even given some of the difficult discussions about decoupling and disengagement, et cetera, the reality is that there's still a huge amount of trans-border penetration, of economic activity, of technology usage, and that's opened up not only just opportunities, of course, but also potential threats and challenges. And I think in a lot of cases, what we see in the Chinese thinking is that they don't really know how this is all going to roll out. And so they're trying to take an approach, as usual, that gives them flexibility in one sense, but may not answer all the questions, for example, for the foreign audience, which likes to have a much more uncertainty on the table than I think the Chinese new laws and regulations are giving them. And of course, we know how the evolution of intellectual property management took place in China, the handling of proprietary information. But I think the handling of data is going to be even more complex and even more challenging for the Chinese leaders. So we saw, as everyone mentioned, the enactment of 3 major pieces of legislation: the June 21 data security law, the August 21 personal information protection law, and also these recent updates to the security law. I also want to add to this, this month, China, I think on March 1, put in place a law designed to deal with the whole area of algorithms and these recommendation algorithms, which are China is trying to, rein in terms of the use of their tech companies, and CAC has played a big role in this. And I think this is really a very broad attempt by the government to tame the use of these algorithms. Now, whether or not it's for personal protection, as it seems to be implied, that's still open to question. But I think that China clearly wants to have some degree of control over what consumers are presented with in terms of what they read, what they watch, and then eventually, of course, what they may buy. Now, I think the elements in all of this, at least from my perspective, with this new legislation have been stimulated by 2 things. And here's where I may differ a bit with what Kendra has said. I think the national security aspects are very, very important. And they are important because the uncertainty surrounding how this data could be used for or against Chinese interests. So I think that this element should not be put in second place somehow. I think it really is very, very, very important, and we need to remember that. But the other thing is that there's so much uncertainty about these regulations that they're not finely tuned documents. They reflect a broad set of requirements that are subject to varied interpretation, varied adaptation, and even uncertain implementation. Compliance, basically reading the documents, can be tight or loose depending on the circumstances. The players involved can, again, be tightly or loosely controlled. And I think this is very consistent with a style of policy making where the concept of purposeful ambiguity is built in. And purposeful ambiguity is another way of saying the government would like to have ample leeway so it can make adjustments over time, just in case they need to tighten things more than they anticipated, or loosen things in case that's the direction they want to go. But I think it's very safe to say that what we're starting to see is a stricter set of policy directives and regulations regarding data privacy and security. And I think for foreign companies in particular, it's going to make it more difficult to do business in China simply because the uncertainty quotient is going to be higher. And as Paul and Kendra have remarked, and Sourabh also remarked, concepts like national core data, important data, they really wreak havoc to foreign companies as they're trying to figure out, what they have to do in order to be legit and not break these laws. So a second element I want to talk about in these laws is that they give a lot more discretionary authority to provinces and municipalities for local interpretation and compliance. And this is not unimportant because it reminds me of the early days of foreign investment in China. You might go to Shanghai and the Shanghai officials would give you a deal and they interpret the central government investment prerogatives in a certain way. And then 2 weeks later, you might travel to Wuhan or Chengdu and they say, well, they may do it that way in Shanghai, but we don't do it this way here in Chengdu or Wuhan or wherever the case may be. And I think that we've got to be careful that we don't get this location by location interpretation of rules and regulations. Companies clearly are looking for more predictability in the business environment rather than greater uncertainty. And this part of it does raise the uncertainty element. The third element I want to mention, again, was just slightly mentioned by the others, and that is this extraterritorial reach of these agreements, and particularly the notion that even if you aren't physically present in China, but you are doing business with Chinese consumers and therefore are dealing with Chinese data, you may eventually have to open up an office in China in order to have a data management explaining to the Chinese government what data you're using, how you're using it, how it's categorized, et cetera, et cetera. That's going to impose an added burden on companies if they don't want to be locked out of the market. A fourth element I want to mention, and I think this is very important, this is just the beginning. And as Kendra said, if China actually goes through and does categorize all this data into the minutia that it seems to want to go in, I think they may be doing themselves, shooting themselves in the foot ultimately. But I think that, as China is one of the first economies out of the digital gate, and it sees itself building this digital economy, it is going to take more and more concerted action. So we're not at the end of a process, we're at the beginning of a process, and we can expect more. Now, I think this is also all about all forms of economic power and the way that information is used as power in the digital age. And one of China's core advantages is simply its sheer size in terms of the amount of data that it has generated and will generate into the future. Chinese officials, I think, today recognize very well that in a world where data is power and information is like the new petroleum of the world economy, that data is going to drive economic advance and technological innovation, and a laissez-faire approach is only going to get them into deeper trouble. So as is typical in China on many occasions, the pendulum clock swings 180 degrees. We go from no control to tight control, or almost tight control. And I think that China needs to be careful. Now, we must remember how this is all being controlled. At the center stage of all of this is, of course, the Cyberspace Administration of China, a very interesting organization because it has, it's the internet regulator, it's the censor, it has oversight, and it's the control agency for all of this that's going on. It's not a small organization, and its domain of reach is only becoming bigger and bigger and bigger. And also, we should remember that CAC is also the majority owner in the China Internet Investment Fund, which means that it has ownership stakes in certain technology firms like ByteDance, Weibo, SenseTime, et cetera, et cetera. So this is not something that we can look aside. Also, the agency is not without controversy as well. We know that Liu Wei, the former director of the agency, was arrested for all sorts of what they call shameless, extremely disloyal, double-faced acts, and one group said that the Central Commission for Discipline labeled him in such a way that it was the harshest condemnation ever provided against any corrupt PRC official. So I think, this says that this agency is also being under surveillance, even though its job is also part of this surveillance. Now, just a couple more points. I had some firsthand experience with all of this because when I was the executive vice chancellor at Duke Kunshan University, we had lots of interface with CERNET and the Chinese government about our treatment of data for students and faculty. And you can imagine in a joint venture university with a US partner and a Chinese partner, there's a tremendous amount of information that goes across borders, particularly since we give a Duke degree and we also give a Chinese degree. And we have 65% Chinese students. So there is Chinese data that is being stored not only on computers in China, but potentially on computers in the United States, especially because at least one semester, these Chinese students will go and spend their time at Duke, which means their file, or in Chinese terms, their dangan, is going to go over to Duke University, at least for a semester. And when it comes time for graduation, all the data about their experiences is going to go to Duke so that their degrees can get approved. So we have to have a very intimate relationship with CERNET, lots of discussion going on all the time. And I know the OIT people in Duke University spend a tremendous amount of time following these data regulations to make sure that we're not running in misalignment with the Chinese government policies. If the data regulations get tighter and tighter, it will be very difficult for these joint venture universities to operate and have this free flow of data. It's already difficult, as many people know. We have a special access through CERNET to the internet and a direct link into the Duke network and the Duke library, but that's not the case in most other universities, and joint venture universities would be severely affected. Now, I want to step back just for 1 minute and then look at this even in a larger context. I spent a lot of time following China's international science and technology relations. And these days, China is all about remaking the rules of the game to accord with its own perspectives about control of where standards are going, where information sovereignty is going, et cetera, et cetera. And so while others on the panel, made the point that China, is concerned about data, I want to even take it even further. I think that China right now is shifting from rule taker and even sometimes rule breaker to international rule maker. And as international rule maker, China's actions that it engages in both domestically and in bilaterally and multilaterally are going to have a big impact, I think, on the international system, both on a regional basis and on an international basis, because I think more and more countries are skeptical about accepting a US generated solution to this kind of problem. And we've already heard the US situation is in Chinese, luan qi ba zao, it's all over the place. So I think that if the Chinese come up with a ready solution that some of these governments can feel comfortable, China is going to have a big influence on the future trajectory of how data is dealt with among these very different countries going forward. Now, one area where Chinese actions clearly are going to have some weight is in the Belt and Road Initiative. No one has mentioned that today, but I think this is something that we need to think about. 65 plus countries or more in which China now is building the digital Silk Road. And of course, one of the reasons why China is in there is to get these countries to begin to align more closely with Chinese ways of doing things, Chinese rules of the game, Chinese protocols, Chinese technical standards. And companies like Huawei and ZTE, as well as the deployment of the Beidou satellite network, are all creating a pathway to the future in which Chinese influence is only going to grow in this part of the world. And in particular, after 2019, when Xi Jinping promised to clean up the Chinese Act with respect to corruption and better mutual benefit, et cetera, if China is able to improve its image, its influence is only going to grow in this part of the world. So let me just conclude with one final comment. whether it's data security or personal information or cyber law. I think this is all about China's recognition of the economic and commercial value of the data and its potential national security dimensions if it were to come to that in terms of a conflict. And I think Chinese now are becoming much more concerned about what the future may be like ahead. I think China is likely to tread slowly at first in terms of the implementation of these new laws and provisions, and we can see there's still continued discussion about implementation, but I think we need to prepare for some challenging times ahead, would be my conclusion. And the reason for my concern really is that we've entered a period where China's relations with the United States and other Western countries are likely to remain problematic for a while. And China, I think, is only going to become more xenophobic about the world, especially as the Biden administration doesn't seem to want to make radical changes from what was in place during the Trump administration. And a more xenophobic China probably is going to mean a more techno-nationalistic China. And that could reveal itself in a direction where there's tighter interpretation and application of laws like this to make it even more difficult for foreign companies to do business in China or foreign universities, be that as may. I think the Chinese are trying to tell us there's a new sheriff in town, and that's reflected in the stronger efforts to apply the requirements embedded in these laws, and we could see the worst that's yet to come. I agree, a lot of this stuff is innovative and creative, but it's going to be very interesting if China moves, in fact, in the direction that I've suggested. And the bottom line is very clear. Data governance regarding China on a national, regional, or global level are all going to be greatly affected by China's increased assertiveness in this area, particularly over the next 4 to 5 years as China begins to move ahead in a much more, I think, a heavy-handed kind of way. And I'll stop right here.
Thanks, Dennis. I think our time is really limited, but we're going to get questions to specific panelists. I think the first question is for Kendra, which is from Niels Bayer on the question, the new draft of the data security management measures in industry and information technology from the mid-February removed a provision that core data must not leave the country. How do you interpret this?
Funny you should mention that. We also, our eyebrows went up when that happened. Frankly, I think it's a super boring answer. I think the answer is by restricting all core data in the measures from leaving the country, when you don't even know what core data is yet, you set yourself up for failure. You're immediately going to run into a situation where some core data has to leave the country, and you can't because it says it in this document, right? It's easier to leave yourself the leeway to just disapprove, to assume you can't send it out and leave a little bit of leeway in there. So that's kind of how we read that.
There are a couple of questions for Paul and also for Kendra. For Paul is, can China compromise on their data regulation, data laws when China applies for CPTPP, as you mentioned in your initial remarks?
Yeah, great comment. And I think you need to look at both DEPA and CPTPP, because the DEPA also has these provisions about, against data localization and allowing free flow of cross-border data. But I think, as Kendra notes there, it's tricky because China hasn't finalized some of these definitions of data. And so there does seem to be flexibility there. And again, they haven't really said, if you look at the language in the regulations, it doesn't say you can't transfer data. It says it has to undergo a review. And so it seems as though there is potentially flexibility within the law and the way it's implemented that could align with some of these provisions. Now it's going to be tricky because if you do restrict core data, how do you interpret that? But the fact of the matter is, a lot of Chinese companies, for example, also the other thing is that a lot of these laws apply to Chinese companies first, right? They're trying to get DD, they don't want DD transferring, personal data outside of China. So I think what the complicated part is once they apply these to domestic companies that are handling large amounts of personal data, for example, then they'll look at foreign companies, because there hasn't really been a case where a big foreign company has undergone the cybersecurity review. It's not clear that they're going to be considered critical information infrastructure providers, for example. So we don't really know how they would implement some of the provisions with foreign companies who need to transfer data in and out of China for valid business purposes. They haven't stopped that, but they're going to eventually get around to figuring out how they review foreign companies in addition to the Chinese companies there. So I think there's leeway here, but the regulation is very broad and the data regime is very complex and comprehensive. But the devil is still going to be in the details of how they implement it. And there are certainly, it seems like, the potential flexibility in there, but that's going to be a complicated negotiation with both DEPA and, of course, then CE. Maybe easier with DEPA, and then maybe the CPTP process is not going to be easy necessarily. But I don't think they embarked on this knowing that with the idea that their laws were just going to prohibit them from being even considered. I think part of it is a political gambit, because the U.S. to show that they're they're at least being taking an initiative in the region, because countries in the region want this. Singapore and Malaysia, as I said, both really want China and U.S. in something like CPTPP, because it's good for everybody there. And so I think we have to be careful not to dismiss out of hand the data provisions here. The other part, like SOE support, and there's lots of other issues with CPTPP, but for DEPA and some of these smaller plurilateral agreements, I think that there's enough flexibility that, and if there's political will, that they could come to agreement on how they're going to implement those laws on data.
Can I just make a quick response?
Dennis, before you do that, I'll just pose the question to you and to Sourabh. That is, a couple of questions. What do these laws, regulations, passed or adopted by both countries mean for the multinationals, for TikTok and WeChat here in the US, for Apple and other companies in China? Is there a data cold war between the two? What are the guardrails and how, where's the common ground? So I guess, Dennis, you go first, and Sourabh, you go second. And
okay,
then
I'll try to be quick.
Can follow up.
Okay, and my comment applies to what I was going to say about Paul. I think everyone has been looking for the increased normalization of the Chinese business environment, and the U.S. always has argued that what we do have here is we have a predictable, stable business environment that everyone knows the rules of the game as they come in. I think what's happened is that this all has been turned on its head. We went from a period from the 80s up to WTO, where it was a greatly uncertain business environment. Then WTO is supposed to normalize that and give us all the rules. Now, I think what we're hearing from people, and again, Paul used the word leeway. I think Kendra used the word flexibility. I used the word uncertainty. I mean, these are all part of the same spectrum of, does it make it more or less difficult to do business? I think it makes it more difficult because it would be good if we know what the rule is and we can measure what we have to, put on the table against some very clear code or classification system. I don't know if we're ever going to get there. And what makes me nervous about it is that we end up with a negotiated system. Everybody is doing their own deal, negotiating with the authorities in a special way. And then the further we get away from standardization of practice, the more uncertainty, the more room for corruption, et cetera, et cetera. So I think we've got to be very careful here that when we use words like leeway and flexibility, we're also not accepting what might be a big problem for companies in the years ahead.
What I would say to your question, Yawei, is that what I see in terms of the bent of where the Chinese are going, it was from localization to conditional localization to allowing greater flows. And I think where the dynamic currently is, I think the real issue is with regard to what is the security assessments that they're going to conduct. I think, the reason they are being discriminated, things like on important data, et cetera, they're putting so much detail out there is to enable its flow, not to lock it up. But that is now being conditioned by the security assessments. And that is where foreign businesses have the issue as to how cumbersome is the security assessment going to be. And therefore, how easy is therefore flow going to be? But the bent is to allow cross-border flow rather than pigeonhole it. And that's why, you know, I am optimistic. I saw one question with regard to can we have common standards? You know, if the guys who are driving digital flows in Asia are actually Singapore, Australia, et cetera, it's a great thing. And I mean, it's a little ironic to have to say this because US has always been the leader in free trade and in standard setting, but on data, it's actually become a little bit of a laggard, and therefore it cannot be too prescriptive in a way, particularly to block China out, as it has done in CPTPP, not in CPP, in TPP. Therefore, if it's left to Singapore and Australia, they can create frameworks which are enabling for all parties to gravitate towards. And I think the Chinese see advantage in that, and that's why they're moving on that line. I'd like to just say one last thing in terms of support to what Kendra said. And I think this is a little bit of a wake up for the American side. You know, one of the greatest points of pride for America is in terms of its capital markets. You talk of open, what is it, deep, liquid, dynamic, open capital markets, the great strength of America. And we might be coming to a day when 30 years down the line in China, we talk about China and we talk about deep, liquid, dynamic, and more or less open data markets. And we need to think of that in terms of then how do we compete? And I think that would be a useful wake-up call. But I actually feel, coming back to the question of digital trade agreements, there's more in common happening out here where everyone perhaps can gravitate to a common platform rather than actually move out in a decoupled way on data. Though, I mean, where US and China, when they come bilaterally engage each other bilaterally on data, I'm afraid, I don't know, it's still open, but it doesn't seem to look terribly good.
Thank you. There were still quite a few questions in the question mark. Let me just take a few more and give a question to all the panelists, and feel free to jump in if you have any idea to respond to the question. For instance, one question is related to what are implications for the US-China data competition for transnational cooperation? What role can they play to either adapt to this new reality or reverse the worsening division? And another related question is still asking for advice. What advice would you give to foreign companies interested in cross-border transactions of data economy when facing tighter and tighter data regulations? Anyone from our panel want to respond to these questions?
I can jump in on the second one, maybe. We get that question from our clients on a daily basis, right? You have all of these, major multinationals basically standing there with a pile of data going, can I send it now? Can I send it now? How do I get this out of the country? And what we're hearing from our clients is that so many companies are in a holding pattern where they're, the Chinese counterpart doesn't want to send it out because there's no clarity and they're afraid that they're going to get in trouble. Specifically, this is an issue with AI because you'll usually have the AI or algorithm outside of China, and then you'll have the data to feed that algorithm inside of China, right? Or it would have been generated in China. And so the company goes, well, we're not sending our AI to China because it's going to get stolen. And, the Chinese side goes, well, we're not sending our data out there because we don't know if we're allowed. And so there's this impasse. And we've heard this again and again and again. And so the answer is not one that companies really want to hear, sorry, but it's, you have to wait, right? Right now, as of last year, what we found out was that, now we've got this pathway for a data export assessment. But if you're, that assessment is being made based on rules that don't exist. It's being made based on data gradations that do not exist. And so if you are the first company, one of the first batch of companies to go out there and apply for a data export assessment, frankly, the CAC is looking at your data and making a relatively arbitrary decision about whether or not they're going to let you send it. So you can do that and cross your fingers and hope you get an approval, or you can wait for more clarity to come out in terms of, wait for the agencies to start going, okay, well, we're going to figure out exactly what data can go and what data can't. And unfortunately, that's probably going to take a few years, right? Depending on what sector you're in. For ICT companies, it'll happen sooner. We already know that's coming out this year. But for companies in other sectors, it might be a longer time. So it's really just a matter of choosing. What do you want to do? You want to be in the first adopter pool, or do you want to hang back and wait for more certainty? And that's a matter of your risk averseness and how eagerly you would like to export your stuff.
And it could send great reverberations across the system if it goes in the wrong direction. In other words, if it could have a very positive impact in terms of easing anxiety, but it could provoke tremendous amount of apprehension as well.
Absolutely.
Anyone want to respond for this question? Otherwise, I would like to thank you all, particularly to our panelists and Dr. Liu for great moderation of this panel. I surely learned a lot. And then there's a lot of information, regulation analysis to be digested. Well, thanks also to our online participants to stay with us today for this webinar. We look forward to see you in our next program. Thank you very much.
Thank you.
Thank you.